I'd like to introduce to you the case of ConAgra Incorporated against McCain Foods Australia Pty Limited, specifically to address the legal principles enunciated in this case. ConAgra Incorporated against McCain Foods involved an action for the tort of passing off, addressing two important legal questions. First, is it necessary that a plaintiff carry on a business or have a place of business in Australia to maintain an action for passing off? And secondly, what is the significance of fraudulent intention on the part of the defendant? The appellant, ConAgra, manufactured and sold in the United States a range of frozen food products under the brand Healthy Choice. The Healthy Choice range claims to be low in fat, low in cholesterol and low in sodium. While ConAgra had no trading or geographical base in Australia, they did have some reputation and had purchased facilities for the manufacture and warehousing of frozen food in country. McCain Foods, already commanding much of the frozen food market in Australia, commenced manufacturing and selling in Australia a range of products using the trademarked name Healthy Choice and imitating the style and get-up of the appellant's product. The marketing director had travelled to the United States, noticing the appellant's product and being sufficiently impressed, returned to Australia with 5 examples of the packaging. To the demise of McCain, the marketing director prepared a report for senior management, commenting on the appellant's product and suggesting the company look closely at this brand in designing their own. It was soon after that McCain lodged an application for the trademark. Were they putting themselves at risk of an action in passing off? An action for passing off stops persons and companies gaining commercial advantage through wrongfully taking the attributes of another's business where it causes or is likely to cause that other person's business some damage. The action depends on 3 core elements. The plaintiff's product or business enjoys a certain reputation or goodwill which is recognised as distinctive in a certain geographical area. There exists a reputation on the part of the defendant that the other's product is the original or is otherwise associated, connected to, or endorsed by the original. And thirdly, the plaintiff has or is likely to suffer damage by reason of the erroneous belief created by the defendant's misrepresentation. In this case, ConAgra argued that sufficient reputation and goodwill existed in the jurisdiction for their brand to establish an action for passing off, despite no established business. The court, in finding that a sufficient reputation did not exist, did advance the common law position, holding that it is not necessary that a plaintiff carry on business or have a place of business in the jurisdiction to maintain an action for passing off. As to fraud, the court found that it is relevant and that the respondent did act fraudulently in designing their product so similarly. However, as the appellant had not established sufficient reputation in the jurisdiction, the appeal was dismissed on all grounds. While ConAgra was unsuccessful, the case did introduce important accommodations for the continuing increase in cross-border training and information sharing. It is now established under the common law that it is not necessary for a plaintiff to carry on business or have a place of business in the jurisdiction to maintain.
Created using Powtoon.